I want us to examine the constitution, the federal constitution that was reached at in Foumban and went into effect on October 1 of 1961. It is important for us to know this constitution in full detail so we can understand how well it's been violated and where we find ourselves today and why we find ourselves where we are. Now, as a background, you know that we were colonized by the Germans, lost the First World War, and so the German territory of Cameroon was taken away from them as a war trophy and divided between the British and the French, who considered themselves at the time to be the winners of that war. So Cameroon was divided between the French and the British. The British had Nigeria to the west. The French had Chad, Central African Republic, Congo, and Gabon to the north, east, and south of Cameroon, the German Cameroon. And so when they divided this territory, the French took about 3/4 of the land and the people, and the English took 1/4 of the remaining portion of the land and administered it together with Nigeria. As we have said in previous programs, after the Second World War, the European nations were really broken and heavily indebted. In fact, Britain owed more than 2 times its gross domestic product in 1 year, the government of Britain. France also owed a lot of money, and they needed reconstruction. The United States had assisted to get Britain literally win this war. And so the United States and Russia and other countries insisted that the European nations that had colonies all around the world, particularly in Africa, must prepare the different nations towards independence. We had indicated in our previous programs that the people of the former British Southern Cameroons, who were controlled by the British from around 1918 through 1961, debated among themselves and wanted to be totally independent as a separate state. But in the United Nations, unfortunately, Andrew Cohen, who represented the British, insisted that we would not be able to survive as an independent state, that we were too small, our economy was not strong, and that we can only become independent by joining Nigeria or joining La République du Cameroun. This was actually not true, as I said in previous programs, because the former British Southern Cameroons, the people of the northwest and southwestern regions of Cameroon, produced much more than we needed for our own needs, but also supported the people of the northern Cameroons that are now with Nigeria. So we had more than enough. Plus, we are bigger than Equatorial Guinea, Gambia, and many other countries all around the world are much smaller than we are and have a weaker economy and less resources than we do. So we were well able to take care of ourselves, but the British and the French connived behind the scenes because they were heavily devastated after the war and needed money. And they connived not to grant us true independence. They wanted to pretend that they had granted us independence by allowing somebody who looks like us, a black-skinned looking individual, taking over, but they will control the economy and the resources and everything. So the British wanted to control us using Nigeria, but in agreement with the French, they agreed that since the people of the former British Southern Cameroon were basically very well educated and standing their grounds and may vote not to go the way Britain wanted, they agreed that if we voted to stay with La République du Cameroun, then Britain would get £2 million from France as recompensation for their investments in West Cameroon. And so when that plebiscite took place on February 11th of 1961, and in this case, Foncha won that we should join La République du Cameroun and not Ndele, who wanted us to go back to Nigeria. Then France paid Britain the £2 million, and Charles de Gaulle said, the former British Southern Cameroon is a small gift from the Queen of England, the one who just died. She had come to the throne in 1953. So our forefathers now were compelled to meet La République du Cameroun in Foumban to craft a new constitution. Remember that we were both united League of Nations territories, and eventually United Nations Trust territories that were administered on behalf of the UN by Britain and France. And so in this discussion on the new constitution, the United Nations that owned us would have been there, but they were not. The British who had administered us should have been there to ensure that our rights were defended, but they were not because they had taken £2 million from the French and went away. And so only France came with a republic. I said in previous programs, Ahidjo had promised in the United Nations before the discussions that when we come together, it will be a federation of 2 states that will be respected, and that our heritage of political practices and legal practices and educational system we inherited through the British will be respected, as well as the Francophones will do theirs. So that was the knowledge by which we were meeting La République du Cameroun in Foumban. Now, when they went to Foumban, remember that our forefathers went there in good faith. The British were not there, the United Nations were not there, only Amadou Ahidjo with his cabinet, as well as the French and their experts were there. And yet our forefathers were able to come up with this constitution that I want us to examine. This will help us, because if you see what they were able to come up with and what is prevailing now, you will see how well this has been violated. So remember, Ahidjo had promised that it's going to be a federation of 2 equal states, and our different institutions will be respected. And so this is what they came up with as the Constitution of the Federal Republic of Cameroon that went into effect as of October 1st, 1961. Part 1, the Federal Republic of Cameroon. With effect from the 1st of October 1961, the Federal Republic of Cameroon shall be constituted from the territory of the Republic of Cameroon, hereafter to be styled East Cameroon, and the territory of the Southern Cameroons, formerly under British trusteeship, hereafter to be styled West Cameroon. This is very important for us to see. This constitution stated that it was La République du Cameroun that was coming together with the territory of the former British Southern Cameroon to form a Federal Republic of Cameroon. It is important for people to understand this, because around 1984, 1985, when Paul Biya seceded from this constitution and went back to his state of La République du Cameroun, it means that he had literally separated himself from the provisions of this constitution. Now, going further, he says, the Federal Republic of Cameroon shall be a democratic, secular, and dedicated to social services. It shall ensure the equality before the law of all its citizens. So you did not have a situation where the English speaking will be second-class citizens in that country, or the Francophones, let alone those from the tribe of the president feeling that they are the superior individuals. Everybody within the land of the new constituted Federal Republic of Cameroon will be equal before the law. And he says, the Federal Republic of Cameroon shall be democratic, secular, and dedicated to social services. It shall ensure the equality before the law of all its citizens, and it proclaims it has adherence to the fundamental freedoms written into the Universal Declaration of Human Rights and the Charter of the United Nations. The official languages of the Federal Republic of Cameroon shall be French and English. This is the only thing that La République tries to hang on. This is the only thing that they will say will translate into English and French. The rest they have discarded. The motto shall be peace, work, fatherland. And then he goes further. The flag shall be of 3 equal vertical stripes of green, red, and yellow, charged with 2 gold stars on the green stripe. The 2 stars represent the La République du Cameroun and the former British Southern Cameroons. The capital shall be Yaoundé. The national anthem of the federation shall be O Cameroon, cradle of our forefathers. The seal of the Federal Republic of Cameroon shall be a circular medallion in bas relief 46 millimeters in diameter, bearing on the reverse and in the center the head of a girl in profile turned to the dexter towards a coffee branch and flanked on the sinister by 5 cocoa pods encircled beneath the upper edge by the words Federal Republic of Cameroon and above the lower edge by the national motto Peace Walk Fatherland. Basically, they were bringing one of our beautiful daughters, flanked by the produce of our land, coffee and cocoa, to represent the seal of the land. The subjects, the citizens, federated state shall be citizens of the Federal Republic with Cameroonian nationality. National sovereignty shall be vested in the people of Cameroon, who shall exercise it either through the members returned by it to the Federal Assembly or by way of referendum, nor may any section of the people or any individual arrogate to itself or to himself the exercise thereof. That means sovereignty belongs to all the people of the federated states and not to an individual or a small ethnic group. The vote shall be equal and sacred, and every citizen aged 21 years or over shall be entitled to vote. The authorities responsible for the direction of the state shall hold their powers of the people by way of election by universal suffrage, direct or indirect. Political parties and groups may take part in elections, and within the limits laid down by the law and regulation, their formation and their activities shall be free. Thus, no political party shall be persecuted for expressing its opinion and desiring to come to power. Their activities shall be free. Such parties shall be bound to respect the principles of democracy and of the national sovereignty. Federal authority shall be exercised by a president of the Federal Republic and a Federal National Assembly. Now, part 2, the federal jurisdiction. The following subjects shall be of federal jurisdiction. That means what the federal authorities or government can handle. Nationality, status of aliens, that means non-Cameroonians in Cameroon, rules governing the conflict of laws, national defense, foreign affairs, internal and external security of the federal state and immigration, planning, guidance of the economy, statistical services, supervision, and regulation of credit, foreign economic relations, in particular trade agreements with other countries. Currency, the federal budget, taxation, and other revenue to meet federal expenditure, higher education and scientific research, press and broadcasting, foreign technical and financial assistance, postal services and telecommunications, aviation, meteorology, mines and geological research, geographical survey, conditions of service of federal civil servants, members of the bench and legal officers, regulation as to procedure and otherwise of the Federal Court of Justice, border between the federated states. So it was important to supervise and maintain the border between the federated states. Regulation of services dealing with the above subjects. The following subjects shall also be of federal jurisdiction: human rights, the law of persons and property, law of civil and commercial obligations and contracts, administration of justice, including rules of procedure in and jurisdiction of all courts, but not the customary courts of West Cameroon, except for appeals from their citizens' decisions. So the customary courts emerged from the British rule. It made it easier for the traditional authorities to judge infractions among their citizens, because the British administered by indirect rule, they gave a lot of freedom to the traditional authorities. In this constitution, they maintained that administration of justice, including the rules of procedures in and jurisdiction of all courts, shall be federal, but not the customary courts of the West Cameroon, except for appeals from their decisions. So they could only deal with appeals if it came up. Criminal law, means of transport of federal concern, roads, railways, inland waterways, sea and air, ports, prison administration, law of public property, labor law, public health, secondary and technical education, regulation of territorial administration, weights and measures. The federated states may continue to legislate on the subjects listed in this article and to run the corresponding administration services until the Federal National Assembly or the President of the Federal Republic in its or its field shall have determined to exercise the jurisdiction by this article conferred. Number 3, the executive and legislative authorities, as the case may be of the federation, shall cease to have jurisdiction over any subject of which the federal authorities shall have taken charge. So, wherever under the last preceding article, the authorities of the federated states shall have been temporarily enabled to deal with a federal subject, they may legislate on such subject only after consultation with the Federal Coordination Committee. The chairman of the said committee shall be a federal minister, and the members shall be nominated by the President of the Federal Republic in view of their special knowledge. Then part 3. Part 3 talks about the President of the Federal Republic. The President of the Federal Republic, as head of the federal state and head of the federal government, shall ensure respect for the federal constitution and the integrity of the federation, and shall be responsible for the conduct of the affairs of the Federal Republic. He shall be assisted in his task by the Vice President of the Federal Republic. The President and Vice President of the Federal Republic shall be elected together on the same list, both candidates on which may not come from the same federated states, by universal suffrage and direct and secret ballot. That means if the President came from the eastern side, which is La République du Cameroon, the Vice President will come from the former British Southern Cameroon, and vice versa. If the President came from the former British Southern Cameroon, the Vice President will come from La République du Cameroon. That was the agreement that was signed in Foumban. The offices of President and Vice President of the Republic may not be held together with any other office. So if you were President or Vice President, you cannot hold any other office, which is the reason why when Foncha went to Yaoundé as Vice President, he had to relinquish the post of Prime Minister of former British Southern Cameroon, which was handed to Joa. The President of the Federal Republic shall be elected for 5 years and may be re-elected. Election shall be by majority of votes cast and shall be held not less than 20 or more than 50 days before the expiry of the term of the President in office. In the event of vacancy of the presidency for whatever cause, the powers of the President of the Republic shall without more devolve upon the Vice President until election of a new president. So if something happened to the President, God forbid, illness, or sudden death, or anything of that nature, where he is incapacitated, the Vice President takes over until new elections are held. The President shall take oath in the manner to be laid down by the federal law. Ministers and deputy ministers shall be appointed by the President of the Federal Republic from each federated state at his choice, to be responsible to him and liable to be dismissed by him. The office of minister or deputy minister may not be held together with elective office in other federated states, office as member of body representing nationality in any occupation or any public post or gainful activity. So if you were a minister or prime minister or vice minister, you cannot be a member of parliament, for example. You cannot have more than one post. The President of the Federal Republic shall represent the Federal Republic in all public activity and be head of the armed forces. The accredited ambassadors and envoys extraordinary to the foreign powers. So he shall accredit ambassadors and envoys to foreign powers. He shall receive letters of credence of ambassadors and envoys extraordinary from foreign powers, negotiate agreements and treaties, provided that these treaties, treaties dealing with the sphere reserved by Article 24 to the federal legislature shall be submitted before ratification of approval in a form by the Federal Assembly. That means you cannot just approve whatever the President negotiated. It has to be approved by the Federal Assembly. Exercise the prerogative of the clemency after consultation with the Federal Judicial Council. Confer the Decoration of the Federal Republic. promulgate federal laws as provided by Article 31, be responsible for the enforcement of federal laws and also of such laws as may be passed by a federated state and under the last paragraph of Article 6, have the power to issue statutory rules and orders, appoint to federal civil and military posts, ensure the internal and external security of the Federal Republic, set up and regulate and direct all administrative services necessary for the fulfillment of his task. Now, going further, provided that where he considers it inadvisable, he may, after consultation with the heads of the governments of the federated states, assume authority over such of their services as exercise federal jurisdiction as defined by Article 5 and 6, and may by decree delegate any part of his functions to the Vice President of the Federal Republic. The governments of the federated states shall be bound before adopting any measure which may impinge upon the federation as a whole to consult the President of the Federal Republic, who shall refer the matter to the committee provided by Article 7 for its opinion. The President of the Federal Republic shall refer to the Federal Court of Justice under Article 34 any federal law which he considers to be contrary to this Constitution, or any law passed by a federated state which he considers to be in violation of the Constitution of a federal law. The President of the Federal Republic may, where circumstances require, proclaim by decree a state of emergency which will confer upon him such special powers as may be provided by federal law. In the event of grave peril threatening the nation's territorial integrity or its existence, independence, or institutions, the President of the Federal Republic may, after consultation with the prime ministers of the different federated states, proclaim by decree a state of siege. He shall inform the nation by message of his decision. The Federal National Assembly shall without more be in session throughout the state of siege. Now, part 4, the Federal Legislature. The Federal National Assembly shall be renewed every 5 years and shall be composed of members elected by universal suffrage and direct or indirect ballot in each federated state in the proportion of 1 member to every 80,000 of the population. 1 member to every 80,000. Federal law shall be passed by simple majority of the members. Before promulgating any bill, the President of the Federal Republic may, of his own accord, or on request by the Prime Minister of either state, request a second reading at which the law may not be passed unless the majority required by the last preceding article shall include a majority of the votes of the members from each federated state. The Federal National Assembly shall meet twice a year, the duration of each session being limited to 30 days, and the opening date of each session being fixed by the Assembly's steering committee after consultation with the President of the Federal Republic. In the course of one such session, the Assembly shall approve the federal budget, provided that in the event of the budget not being approved before the end of the current financial year, the President of the Federal Republic shall have power to act according to the old budget at the rate of 1/12 for each month until the new budget is approved. On request of the President of the Federal Republic or of 2/3 of its membership, the Assembly shall be recalled to an extraordinary session limited to 15 days to consider a specific program of business. So 2/3 of the Assembly can call an emergency session. The Federal National Assembly shall adopt its own standing orders, and at the opening of the first session of each year shall elect its Speaker and Steering Committee. The sitting of the Federal National Assembly shall be open to the public. That means members of the public can come and listen, watch them in session and listen to their deliberations, provided that in exceptional circumstances and on the request of the federal government or of a majority of its members may be excluded. Federal elections shall be regulated by a federal law. Parliamentary immunity, disqualification of candidates or of sitting members, and the allowances and privileges of members shall be governed by a federal law. Part 4, relations between the federal executive and the legislature. Bills may be introduced either by the President of the Federal Republic or by any member of the Federal Assembly. Of the subjects of federal jurisdiction under Articles 5 and 6, the following shall be reserved to this legislature: the fundamental rights and duties of the citizen, including protection of the liberty of the subject, human rights, labor and trade union law, duties and obligations of the citizens in face of necessities of national defense, the law of persons and property, including nationality and personal status, the law of movable and immovable property, the law of civil and commercial obligations, the political, administrative, and judicial system in respect of elections to the Federal Assembly, general regulation of national defense, the definition of criminal offenses not triable summarily, and the authorization of penalties of any kind, criminal procedures, civil procedures, execution procedures, amnesty, the creation of new classes of courts. The following matters of finance and public property, currency, federal budget, imposition, assessment and rate of all federal dues and taxes, legislation on public property, long-term commitments to economic and social policy, together with the general aims of such policy, educational system. Bills laid on the table of the Assembly shall be considered in the appropriate committees before debate on the floor of the House. The text laid before the House shall be that proposed by the President of the Federal Republic when the proposal comes from him, and otherwise the text as amended in committee, but in either case, amendments may be moved in the course of the debates. The President of the Federal Republic may, at his request, address the Assembly in person and may send messages to it, but no such address or message may be debated in his presence. So if he presents an article, he doesn't have to sit there and listen. Federal ministers and deputy ministers shall have access to the Assembly and may take part in debates. The program of business in the Assembly shall be appointed by the Chairman's Conference, composed of party leaders, chairmen of committees, and members of the Steering Committee of the Federal National Assembly, together with a federal minister or deputy minister. The program of business may not include bills beyond the jurisdiction of the Assembly as defined by Article 5, 6, and 24, nor may any bill introduced by a member or any amendment be introduced which, if passed, would result in a burden on the public funds or an increase in public charges without a corresponding reduction in other expenditures or a grant of equivalent news supply. Basically, they were trying to practice a balanced budget. So if you brought any matter before the Assembly that was approved and it increases the budget, then they have to cut in other areas. Any doubt or dispute on the admissibility of a bill or amendment shall be referred for decision by the Speaker or by the President of the Federal Republic to the Federal Court of Justice. The program of business shall give priority and in the orders decided by the government to bills introduced or accepted by it. Any business shall, on request by the government, be treated as urgent. The government shall be bound to furnish to the Federal National Assembly any explanation and information on its activities in reply to written or oral questions by the Assembly or to any committee of inquiry set up by the Assembly to inquire into governmental activities. The procedure of all such inquiry and supervision shall be laid down by a federal law. The President of the Federal Republic shall promulgate laws passed by the Federal National Assembly within 15 days of their being forwarded to him, unless he receives a request for a second reading, and at the expiry of such period, the Speaker may record his failure to promulgate and do so himself. That means if the President does not promulgate into law a bill that has been passed by the Assembly, after 15 days, the Speaker of the Assembly can allow it to go into force. Laws shall be published in both official languages of the Federal Republic, English and French. The judiciary. Justice shall be administered in the Federation in the name of the people of Cameroon by the competent courts of each state. The President of the Federal Republic shall ensure the independence of the judiciary and shall appoint to the bench and to the legal service of the federated states. He shall be assisted in his task by the Federal Judicial Council, which shall give him his opinion on all proposed appointments to the bench, and shall have over other members of the bench the powers of disciplinary council, and which shall be regulated as to the procedure and otherwise by a federal law. The Federal Court of Justice shall have jurisdiction to decide conflicts of jurisdiction between the highest courts of the federated states, to give final judgment on such appeals as may be granted by federal law from the judgments of the superior courts of the federated states wherever the application of federal law is in this issue, to decide complaints against administrative acts of the federal authorities, whether claiming damages or on grounds of ultra vires, to decide disputes between the federated states or between either of them and the Federal Republic. The composition of the taking of cognizance by and the procedure of the Federal Court of Justice shall be laid down by federal law. Where the Federal Court of Justice is called upon to give an opinion in the cases contemplated by Article 14 and 29, the number shall be doubled by addition of personalities nominated for 1 year by the President of the Federal Republic in view of their special knowledge and expertise. Warrants, orders, and judgments of any court of justice in other federated state shall be enforceable throughout the federation. Impeachment. There shall be a federal court of impeachment which shall be regulated as to composition and taking of cognizance and in other respects by a federal law. The Federal Court of Impeachment shall have jurisdiction in respect of acts performed in the exercise of their duties to try the President of the Federal Republic for high treason, and the Vice President of the Republic, and federal ministers and prime ministers and secretaries of state of the federated states for conspiracy against the security of the state. So the president and ministers and prime ministers were eligible for impeachment. Now, part 4, Federal Economic and Social Council. There shall be a Federal Economic and Social Council which shall be regulated as to powers and in other respects by a federal law. Now, the federated states. Any subject not listed in Articles 5 and 6 and whose regulation is not specifically entrusted by this Constitution to a federal law shall be of the exclusive jurisdiction of the federated states, which within those limits may adopt their own constitutions. The House of Chiefs of the Southern Cameroons shall be preserved. The House of Chiefs of the Southern Cameroons shall be preserved. The Southern Cameroon insisted on this. La République did not have a House of Chiefs. Legislative power shall be exercised in the federated states by a legislative assembly elected for 5 years by universal suffrage and direct and secret ballot in such manner as to ensure to each administrative unit representation in proportion to its population. Provided that in West Cameroon, the House of Chiefs may exercise specified legislative powers to be defined together with the members, the manner of exercise by a law of the federated states in conformity with this constitution. There shall be 100 representatives in the Legislative Assembly of East Cameroon and 37 representatives in the Legislative Assembly of West Cameroon. The electoral system, qualifications for candidates, and disqualification of sitting members, parliamentary immunity, and the allowances of representatives shall be regulated by a federal law. Each legislative assembly shall adopt its own standing orders and shall annually elect its steering committee. It shall meet twice a year the duration of each session being limited to 30 days on dates to be fixed by the steering committee after consultation with the Prime Minister of the Federated States, and so that the opening date of the budgetary session shall be later than the approval of the federal budget. On request of the Prime Minister of the on request of the Prime Minister, of the President of the Federal Republic, or of 2/3 of his members, it shall be recalled to extraordinary session limited to 15 days to consider a specific program of business. So the Prime Minister of each state can recall the assembly, just as the President can recall the assembly, but also 2/3 of members of the assembly can request the assembly to come and sit. The sittings of each legislative assembly shall be open to the public, provided that in exceptional circumstances, on the request of the government or of a majority of its members, strangers may be excluded. Bills may be introduced either by the government of each federated state or by any representative in the Legislative Assembly, and shall be passed by a simple majority. A motion of no confidence passed by a simple majority, or a vote of censure passed by an absolute majority, shall oblige the Prime Minister to place his resignation in the hands of the President of the Federal Republic, or be declared to have forfeited his office, and the President may then dissolve the Legislative Assembly. Persistent discord between the government and the Legislative Assembly shall enable the President of the Federal Republic to dissolve the latter of his own accord or on the proposal of the Prime Minister. New elections shall be held within 2 months of dissolution. Until investiture of a new Prime Minister, the outgoing government shall be responsible for the dispatch of current business. That means they will continue to operate to serve the public until a new government is voted within 2 months. The Speaker of each federated state shall within 21 days forward bills to the President of the Federal Republic, who shall within a further 15 days promulgate them. Within the set period, the President of the Federal Republic may either request a second reading by the Legislative Assembly or act under Article 14. At the expiry of such period, the Speaker of the Legislative Assembly in question may record the President's failure to promulgate and do so himself. So if the Southern Cameroon Assembly passed a law and sent it to the President and he refused to promulgate, the Speaker can pass it and promulgate it into effect. Insofar as they do not conflict with the provisions of the Constitution, the existing laws of the Federated States shall remain in force. Now, Part 10, and this is very important. Article 47. No bill to amend this Constitution may be introduced if it tends to impair the unity and integrity of the Federation. So no bill could be introduced to basically compromise this Constitution. Bills to amend the Constitution may be introduced either by the President of the Federal Republic after consultation with the Prime Ministers of the Federated States or by any member of the Federal Assembly, provided that any bill introduced by a member of the Assembly shall bear the signatures of at least 1/3 of his membership. The amendment may be passed by a simple majority of the membership of the Federal Assembly, provided that such majority include a majority of the membership elected from each federated state. The President of the Federal Republic may request a second reading of a bill to amend the Constitution as of any other federal bill and the like manner. Transition and special. It goes further. The jurisdiction defined in Article 5 shall pass without more to the federal authorities as soon as they are set up. The government of each federated state shall forward to the federal government all papers and records necessary for the performance of its task, and shall place at the disposal of the federal government the services destined to exercise federal jurisdiction under the authority of the latter. Notwithstanding anything in this Constitution, the President of the Federal Republic shall have power within the 6 months beginning from 1st October 1961 to legislate by way of ordinance having the force of law for the setting up of constitutional organs and pending their setting up for government procedure and the carrying on of the federal government. The President of the Republic of Cameroon shall be, for the duration of his existing term, the President of the Federal Republic. For the duration of the term of the first President of the Federal Republic, the Prime Minister of the West Cameroon shall be Vice President of the Federal Republic, and the disqualifications prescribed by Article 9 for the Vice President of the Federal Republic shall, during that period, be inapplicable. With effect from the 1st October 1961, the National Assembly of the Republic of Cameroon and the House of Assembly of the Southern Cameroon shall become the first legislative assembly of East Cameroon and of West Cameroon, respectively. Until the 1st April of 1964, the Federal Assembly shall be composed of members elected from among themselves by the legislative assemblies of the federated states according to the population of each state in the proportion of one member to 80,000 of the population. Notwithstanding the provisions of Article 11, until the election of a federal assembly under Article 16, the offices of federal minister and deputy minister may be held together with parliamentary office in other federated states. The government of the Republic of Cameroon and the government of Southern Cameroon under British trusteeship respectively shall become on the 1st October 1960 the governments of the two federated states. Pending the setting up of the Federal Economic and Social Council, the Economic and Social Council of the Republic of Cameroon shall be preserved. Pending approval of a definitive federal budget, a provisional federal budget shall be drawn up and shall be financed by contributions from each federated state to be settled after agreement with the government of each such state. This constitution shall replace the Constitution of the Republic approved on 21st February 1960 by the people of Cameroon, shall come into force on the 1st of October 1961 and shall be published in its new form in French and in English, the French text being authentic. For the purposes of this constitution, the population of each federated state shall, on the 1st of the statistics of the United Nations Organization, be taken to be as follows: East Cameroon, or La République du Cameroon, 3.2 million people, and West Cameroon, or the former British Southern Cameroon, 800,000. Such figures may be amended by a federal law in the light of significant variation established by census done in Yaoundé on 1st September 1961, signed by Amadou Ahidjo. So, my fellow people, I wanted to read this constitution. I'm not a great reader, but I hope you were able to get the information. This constitution is very easy to get. You go online on Google and just Google the Constitution of the Federal Republic of Cameroon drawn in 1961, and you will see it come up, and you can read for yourself and have the full details. You can see that our forefathers nearly abandoned to themselves, meeting Ahidjo with his cabinet and the French in Yaoundé, in Foumban, were able to come up with this constitution, and they tried their best. It's important to note here that Ahidjo took this to his house, they approved it, but our house in Boyal did not vote this into force. And we had a very vibrant legislature that debates issues and take their responsibilities very seriously. The fact that our house did not vote this into law basically means that there is no treaty of union between La République du Cameroon and the people of the former British Southern Cameroon. Now, if you want to go by this constitution, you realize that coming on forward, the French presidency, the Élysée, co-opted Mouna and Egbe around 1963 to collaborate with France to compromise our institutions. And in fact, all of our forefathers, if you examine them individually, they all have their areas of weaknesses and errors. Remember, these were young people. Some were in their 30s, a few were in their 40s, and very few who would have been maybe in their 50s, like Mona, who was born as the oldest among them around 1914. And Fonja was born in 1924. Ahidjo was born in 1924. Now, so you realize that by 1966, using Endele campaigning Ahidjo was able to basically abolish all political parties and enforce only his own Union Cameronaise to become the national party that absorbed all the other parties, and the party leaders became section presidents. And then progressively from there, after Foncha had to give up his position as Prime Minister of West Cameroon because he could not put many posts together, he went to Yaoundé. Ahidjo tried to impose Muna on the children of former British Southern Cameroon, but the National Assembly of West Cameroon booed and jeered because, number one, Muna was not of the KNDP that had the majority in the House. And by the practice of our political system, the Prime Minister comes from the party with majority in the House, which was the KNDP. And so, as Foncha, Ahidjo was compelled by our members of the House to choose Joa, and so Joa became the Prime Minister. They preferred to use Mona because they had already been compromising him, and they were going to collaborate with him to destroy our infrastructures. And with time, Ahidjo got rid of Joa and put Foncha in that position of Prime Minister in 1968. So ashamed because he could not do well with our house that he ran and was living in Yaoundé when the Prime Minister had to live in the capital of the territory of this federated state. But anyway, you can see from here how this proposed constitution was compromised. The one article indicated that no provision put into debate will compromise the federated nature of the constitution or the coming together of the two states. So that when Ahidjo now came up in 1972 with the so-called referendum changing the federated states into United Republic of Cameroon, that was already a violation of this law. He had already demonstrated his ability to violate all those laws, and this was under the guidance of the French. So Ahidjo was acting under the leadership and guidance behind the scenes of the French, and so he compromised our practice, even to the point where he also compromised our state by bringing forth the United Republic of Cameroon in 1971. And I had read in previous programs how he humiliated Foncha, calling him to his office after he returned from France in May of 1972 and telling him that he personally had decided unilaterally to get rid of the Federation, arrogantly. And when Foncha said it was against the law, he laughed and said, "I'm done with you, get out of my office." And when Foncha went to talk with his other English-speaking brothers, he realized that they had been bribed, they had been compromised. So that is what has happened with this constitution, using bribery and corruption, starting with Muna and Egbe. They bribed them to collaborate to destroy our infrastructures. Then they continually bribed our people and got rid of all our infrastructures and introduced the current so-called constitution, which they continually violate. They hardly respect the components of that constitution. They pick and choose what components to do. And so when in 1985, around 1984, 1985, Paul Biya seceded from the Union by reverting to La République du Cameroun. Basically, he went back to the portion of territory that met the people of the former British Southern Cameroon in Foumban to debate this constitution. So basically, Paul Biya seceded from the coming together of the two groups. And so that's why other knowledgeable legal minds of the former British Cameroon told him that he should be logical with himself. If he is seceding to what he was before we went to Foumban, he should pull his administrators, officers, and police back to the boundary. Remember, this constitution recommended for the president to respect the boundaries between the federated states. So he has violated that portion where he was not even respecting the boundaries between the two states. And remember, the former British Southern Cameroon has internationally recognized boundaries with pillars planted. I know I'm not a great reader, but I tried my best to read that constitution. Like I said, it's an easy document to find. You go to Google and you Google the Constitution of the Federal Republic of Cameroon of 1961, and you will find it. To read it in detail, you read much better than I tried to put it out here. But I just thought I would bring this for our people to know, so you can see how we have been betrayed and violated to the point where we are being treated as second-class citizens. Yet that document said every person of Cameroonian nationality, after the coming together of the two states, are equal before the law. That to the point where even the president and the vice president and ministers and officers of the state could be impeached for wrongdoing, because no human being is perfect. We all do wrong things. And so, if the president acts in violation of the constitution and threaten the life of the people of Cameroon and the nation, then he could be impeached and removed from office so that a more competent person can take over. And so, anyway, I will stop here for today. That is what I wanted to bring to the knowledge of our people. Thank you very much. Paddy, Paddy. Lord.